Justice Alito?
Did the plaintiffs raise overbreadth below?
No, Your Honor. I'm not. I couldn't find the word overbreadth in any of their pleadings.
Where in the record should I look to find a list of all of the platforms that are covered by the Florida statute?
Well, Your Honor, I'm afraid that doesn't appear in the record because I think the platforms were fairly cagey about which of their members they thought the statute applied to. The record only contains 3 platform-specific declarations: Etsy, Facebook, and YouTube. So that's part of the problem in this case, is that we don't have a sense of the record has not been fully developed to answer that question, so we're kind of litigating in the dark here, and this was litigated on a preliminary injunction at breakneck speed without the state having a chance to take discovery, and that's part of the reasons why some of these questions are difficult to answer.
Well, I'll ask Mr. Clement that question too. As to the platforms that are covered, where in the record would I look to find a list of all of the functions that those platforms perform?
I'm not aware in the record, Your Honor, of an all-encompassing list of all the functions the platforms perform. There certainly are, as I mentioned, 3 platform-specific declarations, also some more general declarations that talk about some of their members more generally, but it's not sort of all in one place. I apologize, Your Honor.
Does your law cover any websites that primarily or even exclusively engage in non-expressive conduct?
I think it does cover websites that engage in primarily non-expressive conduct. I mean, we would characterize the social networking platforms as engaging in primarily non-expressive conduct insofar as they are hosting speech, just like a traditional common carrier is not engaged in expressive conduct in transmitting the communications of its subscribers. And we do think our law would apply to certainly the largest, at a minimum, the largest social networking platforms.
What is the right standard for a facial challenge if we think that your law implicates a percentage of expressive conduct and a portion of non-expressive conduct? How should we analyze that?
I think that you would
So we need a numerator and a denominator there, I think. What would they be?
Well, I don't think there isn't the standard would have a numerator and a denominator, actually, Your Honor, in this context. We would view it as the question being whether the statute has a plainly legitimate sweep without the need to compare applications. As I understand this Court's precedents, the numerator-denominator comparison would be something you would do if there were an overbreadth claim in this case, but I don't understand my friends to be making an overbreadth claim. Maybe they'll say something different, but I could not find the word overbreadth in their pleadings. In the Texas case, they do have a footnote suggesting that they made an overbreadth claim in the alternative.
Thank you.